I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, family? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are jumping into number 60 in our compilation series. That's right, this is number 60. And today we will be in 3 different judges' courtrooms. Now, before I give you the rundown of those judges, just know there will be no commentary at the end of this, and also chapters will be added for your convenience. Now, as far as the judges go, the courtrooms that we're going to be in on today, first, we're going to be in the courtroom of Judge Monica McCoy Purdy out of the state of Texas. Second, we will be in the courtroom of the 44th District out of the state of Michigan. And last but not least, we will be in the courtroom of a fan favorite by the name of Judge Simpson out of the state of Michigan. Guys, don't forget to like, comment, share, subscribe, whatever it is that you can do to help this video be shared and also to continue to help the channel grow. With that being said, guys, I'm excited. I hope you are too. So let's go ahead and jump into our 60th compilation.
Council, going to call your 9 o'clock case. We are on the record in cause number DC 23-03286. Delta Victor LLC versus Lisa Irene Writing et al. May I have you to announce on the record? Let me know your name and who you represent.
Good morning, Your Honor. John Dubiel for the plaintiff.
All right.
And Lisa Irene Writing Nyber in full life sui juris, as well as by special appearance, not generally today.
Okay, and you're representing yourself, is that correct, Ms. Writing?
I am representing the beneficiary of the uppercase name in the estate. Yes, ma'am.
Okay, and are you a lawyer, Ms. Writing?
No, I am attorney in fact.
I'm sorry, I didn't understand you.
I am a private attorney in fact.
Private attorney in fact, what does that mean?
It means specifically that I have a private exclusive power of attorney over the estate affairs as its beneficiary, and I have a right to conduct business that is necessary, including legal matters.
Okay, my question to you was, were you a licensed attorney?
No,
in
ma'am.
the state of Texas?
No, ma'am.
Okay.
And it's clear of my status as well. That has been submitted to court from my very first appearance.
Okay, counsel for the plaintiff, this is your motion to disperse funds. Let me hear from you at this time.
Thanks, Your Honor. So back in August of last year, this court entered summary judgment in favor of plaintiff for $970,000 and 15% in interest per annum. In March of this year, the defendant delivered a purported check to the Dallas County registry in the amount of $1,350,000 and received a receipt for that amount from the registry of the court. And that, quote, certified funds and the receipt are attached as Exhibit A. In April of this year, the Dallas County Court and Bank of America North America Treasury Servicing and Operations exchanged a series of emails regarding the validity of that check, and the latter showed that those funds were fraudulent and recommended reissuance or wire transfer. In July of this year, the defendant sent another purported payment in the amount of $1,350,000 to the registry of the court. That purported payment is also attached as Exhibit A. In August of this year, David Bradley, who is the accounting and collection supervisor for Dallas County District Clerk, wrote an email to the plaintiff stating that the only valid payment he has received in conjunction with this case are the filing fees that I paid in March of last year. So it's my understanding that the plaintiff a representative spoke with Mr. Bradley yesterday, who again confirmed that there are no funds currently with the registry of the court. Now, although this motion is entitled Motion to Disperse Funds, it's clear there are no funds to disperse. I've also cited authority that the court has great latitude in dealing with these funds and has the equitable power to make such orders as it deems necessary to protect them. So to that end, I uploaded an additional order yesterday for the court's review, which would require the defendant to make payment in the form of cash check, money order, or wire transfer. However, I'd like to strike through check, given that 2 fraudulent instruments have been submitted to the court already. And so I would ask the court to sign the order in the form uploaded, but strike through check.
All right. And did you mention that you uploaded an order on yesterday? If so, I don't see it on our system just yet, but I can go and pull it down. The last order that we have, it looks like it was uploaded on September 3rd.
I can do that, Your Honor. It was yesterday. It has been accepted. I thought that I emailed it to Ms. Alonso as well. If not, I can certainly do that.
Okay. If Ms. Alonso has it, then I can get it, but we'll confirm that.
Okay.
All right. Counsel for the plaintiff, is there anything else regarding your presentation?
No, Your Honor.
All right. Mrs. Writing.
Thank you for appropriately addressing me. And to correct a few items, and just in summary, is I also submitted a corrected order for disbursement yesterday, and it was received as well. So you should have 2 of them there, Your Honor. Also in correcting, I did not provide a check. I also provided what is called a negotiable instrument. That negotiable instrument was against a bond and is legal tender, and it was received, and there is an official receipt on file for that. That was filed on 3/15, and on 3/29, the trustee and clerk of the court, Felicia, moved it directly to the plaintiff. On 4/8, you signed a order that the case was closed. As part of that process, it clearly states specifically on the receipt that it has to be held for 30 days because it could be appealed, as you know. It was only after continued trespassing was occurring by a bar member that I submitted a second payment. And I appreciate the trustee's office because they returned the second payment with a note that said tender payment had already been made. I appreciate them staying in honor. Since then, I have also filed an IRS corrected 1099-A form, primarily because the TT&L operator and the money logs, 120 logs, actually showed that the case had already been prepaid. In addition, I have done some research and requested through the Treasury directly the bond number on this case and docket. They refused, but my broker was able to find it directly. So as part of that process, the setup process may be a little bit different than utilizing a check or wire transfer as the plaintiff counsel appears. However, my packet was also submitted with a Form 56 as the fiduciary and the case trustees are mandated to file and also file Title 48. And they're also titled to do the set-offs as required and pull directly from that minor account. I have provided that in a brief of all that has been done, but that tender of payment has been accepted and received. And I instructed, even though I am not entitled to give the plaintiffs any attorney, any legal advice, is to file for the disbursement as the receipt indicates he can do after 30 days. He failed to do so until about a month ago. However, he has additional bar members that are continuing to trespass on the estate and have attempted both in Arizona as well as in Oregon to continue to garnish and also trying to collect on something that has been paid and closed since April 8th.
Miss Writing, let me stop you right there because I'm having difficulty following. what is the relief that you are seeking from this court? You just heard the plaintiff represent his argument that defendant submit funds to the registry in the court in the form of cash, money order, or wire transfer. What relief are you seeking from this court at this time?
I'm just looking for the disbursement to be signed, but according to the one that I submitted. So I submitted a corrected disbursement with the accurate information on it. And I had 2 additional items in which I was asking. My order and adjudicated in decree includes that the court releases and makes disbursement of funds and satisfaction of debt to the alleged creditors. The tender of payment had already been made to the court in accord with 28 USC 2041, USC 307, 304, and 306. The court did not dishonor that tender, and therefore the tender and adjudicated claim in accordance with 2045. I also asked for 3 additional elements. I asked for the case to be sealed because confidential information that the bar member failed to redact and mark as confidential will help protect me from additional identity theft because it has my social security number on it. I also asked that the bar member release ongoing harassment of Lisa Riding in the lower case, as well as trespassing on the estate. And lastly, I asked that the bar member for the plaintiff dismiss with prejudice any additional orders that he has legal action in Arizona and Oregon for garnishments. If one other stipulation here is that if the plaintiff's bar member is refusing to accept legal tender that has already been received by the court, and he's motioning to strike that I use another form of methodology for paying, I would also move to have a motion that he uses his bond to pay it rather than the bond that I was submitted.
All right. Counsel for the plaintiff, brief response.
So as far as the receipt that the defendant has received, that's a receipt simply acknowledging the documents that the registry of the court received in their office. There's actually been no transfer of funds, and that's been confirmed multiple times. One thing I did hear, and I don't believe any personal information has been disseminated to the court, and we certainly have no intention and will not do that. But otherwise, the defendant must comply with the rules of the court, which require cash, check, money order, or wire transfer. But again, I'm going to submit an additional order or ask the court to strike through the use the word check in the order already submitted.
All right. Anything else? Counsel for the plaintiff, since you're the movant?
No, Your Honor.
All right. Ms. Riding, anything else?
I would probably just define, if I don't want to get into semantics here, but, for the plaintiff's attorney, money is defined by the UCC in accord with section 1201-24 specifically. And I can get into an argument of what is legal tender, even down to 18 USC 8, including bonds. But I have provided all legal tender and obligations to the United States in accord with public policy. You, as its trustee, according to 31 USC 5118D 1 and 2, are required to discharge this debt. And legal tender was made at the time of payment, which was on 3/15 and closed officially on 4/8.
All right. I will review the 2 proposed orders that have been submitted to the court. I will sign an order today as it relates to the plaintiff's motion to disperse funds that will be uploaded on our system for you to view. Are there any other questions for the court?
No, Your Honor, other than should I submit a new order or no? Striking through check, word check.
Did you mention that you had emailed also the latest order to Mrs. Alonso?
I believe I did. If not, I will do it the moment we get off this hearing.
Okay. If you can double check, because again, I am going to go to our clerk. Again, the last order that I show uploaded is September 3rd. I will let them know that there should be some more orders out there. Can you pull those down and give them to me so I can review them and get one signed today?
Thanks so much, Your Honor.
All right. If there's nothing further, that concludes our hearing.
Yeah, and Your Honor, I also submitted almost an identical, but with the 3 additional items I was asking for.
Correct. And as I mentioned before, I'll be reviewing both orders, make the determination which one is appropriate in line with the court's ruling. And I will basically sign that particular order today.
Thank you.
Thanks, Your Honor.
Thank you. Take care. Bye-bye.
Bye.
People versus Robert Shaw.
Very good to have people.
We're here by special appearance, Your Honor, and remain in honor and not to argue but to challenge authority.
Your name?
Showman Robert Lewis.
Okay. This is the date and time set for a preliminary exam. Mr. Chauvin appears here on his own. As we've done in the past, Mr. Chauvin, I need to make sure you understand your rights today with regards to the potential to be represented by counsel. We've had this conversation before, correct?
I do not consent to any statutory authority presumed by this court.
Okay. We've had that conversation before about your right to have an attorney.
I am representing the all caps name, Your Honor. I am the attorney.
Okay. Do you want to have an attorney assigned to you?
No.
All right. You understand that if you wanted to, the court would have the Michigan Indigent Defense Counsel assign you.
I understand that.
Okay. You understand also the challenge of the crime that you're charged with?
Yeah, I don't understand that.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st, 2024. Maximum penalty is up to 2 years in prison and a $2,000 fine or 3 times the amount payable, whichever is greater. You've heard all of those maximum penalties before?
I have.
Do you have any questions about that?
No.
And having heard those maximum penalties, is it your request today to proceed on your own without counsel?
Yes.
Okay. You know that I have to treat you as if you had an attorney, correct?
Yes.
Okay. You know that I can't assist you in any way as we go through this hearing. You're going to have to question witnesses on your own. You make the decision on whether or not you want to testify. You understand all that.
I do. Right.
You do?
Yes.
Okay, you do. But I won't be able to help you with that.
Right.
You understand that? Okay. Have you ever gone through a court hearing previously where you represented yourself?
No.
Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. Do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is,
Who's she?
the prosecuting attorney is capable of even speaking in this matter.
I'm not sure exactly what you mean. My question was about a preliminary exam. I'll let you can make your motion here in a moment if that's what you're getting at, but do you have any questions about this preliminary exam?
No.
Knowing all of that, all the understanding and explanation that I just gave you, your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States?
So
is she able to do that?
Are you asking me a question?
Yes.
Okay. I'm not going to answer any questions. You have a motion that you want to make. Are you challenging something? And
yes,
say
like
that the court should move in one direction or another. I'll make a decision on that.
I would like to make a motion to challenge the validity of the prosecutor being able to prosecute this venue.
Based on what? I'll give you a chance. Based on what?
Based on the bankruptcy of the United States of America.
Okay.
Because is she a trustee for the United States of America? That is my motion.
All right. Let's see.
Thank you, Your Honor. Your Honor, I'm a licensed attorney in the state of Michigan. I am employed by the county of Oakland, and I have authority to exercise my prosecutorial duties within any district court within the county of Oakland. Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I've reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and the statutes that are at issue. Mr. Chauvin, you've made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. Have another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process, that this should not even be taking place because I was denied access to documents, records, by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records.
Which records?
My court filings.
Your court filings?
Yeah, that I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice, I guess.
I have something here. With me. Did you get anything?
I did not hear it.
Did you want to review this?
May I approach your Honor?
Any response to what he's talking about?
Your Honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore, they're his documents, so I'm not entirely sure why copies were needed to begin with. So and I also have nothing to do with whatever fees are issued by the court.
Sure. So those fees are again set by court rule and statute, and you know your objection to the court imposing those fines, or not fines, but the fees to get the copies, those are overruled. The court's just following the court rules with regards to that. Your motion is denied with regards to the impact it may have on your due process. If it did have any impact, it would be a negligible one, given the fact that they were the documents that you had submitted. And the court register of actions would just simply confirm that they were actually submitted, which you could have also done by bringing your own second copy, having a true copy made, or a stamped copy returned to you that way. But in any event, I don't believe it has any impact on the way that we're going to proceed today. So again, you made your motion. There's a record of it. I denied it, and we're going to move on to the next. So, do you have any additional motions?
Yes, I have one more motion. I think that this case should be totally thrown out because there was no legitimate warrant, sir.
No legitimate what?
Warrant.
A warrant. Okay.
Which is why we're here in the first place.
No legitimate warrant.
No lawful warrant. I apologize.
Well, before I let you respond, what are your objections to the warrant that they would make it unlawful?
Well, I wasn't notified of a hearing to have the warrant issued, and under law, Public Act 1957, I'm allowed to be at a hearing where a warrant is issued in my name.
Were you denied access to the hearing?
I've never received a notice.
Okay. All right. Continue.
Your Honor, the warrant was issued by the office. It was sworn to by the court, entered into the system. I believe that there is not only case law, but statute, Michigan law, that allows for that to occur without having the person being charged present.
I agree. I'm going to, again, deny your motion. You've made a record of it, though, and that's the court's ruling. So any additional?
No.
All right. Then everyone can have a seat. And did you want to call your, anything from you?
Yes, Your Honor. I would just ask for a mutual sequestration. I'm not sure who this individual in the court is.
Okay. Who's in the court?
This is my wife.
Okay. Is she a potential witness in the case?
Your Honor, is this Kimberly Chauvin?
Yes.
She's listed on here as a witness, so I'd ask that she be sequestered.
Okay. Any comments about that request?
She kind of helped me with counsel though, so.
Okay, she can't do that. She's not, is she an attorney?
No.
Okay, so she can't do that, so that's not a basis for me to deny the request. So the reason that we'll have everybody step out on both sides, so any of your witnesses except for the officer in charge would also need to be out in the hallway, is that all the testimony will then occur and no one will be able to hear it and have that influence the way that they're going to testify. So on that basis, the motion to sequester witnesses is granted. So Ms. Chauvin, you just step out in the hallway and we'll get you when it's your turn to come to testify. Okay? All right. Your first witness.
Thank you, Your Honor. People call Matthew McBride.
All right, so before you get seated, if you please raise your right hand. Do You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. I do. Put your hand down and have a seat. Once you do get seated, if you state your first and last name and provide the spelling of both for the record.
Sorry. Jeez. Can I break this?
Sorry. Tony's.
Sorry. Matthew McBrien, MATTHEWMCBRIEN.
Go ahead and say you.
Thank you, Your Honor. Mr. McBride, where are you employed?
Credit Union 1 in Berkeley.
And what is your job?
I'm a teller.
I'm going to draw your attention to May 31st of 2024. Were you working that day?
Yes.
And are you familiar with a Robert Chauvin? Did
Yes.
you see him in the courtroom here today?
Yes.
Can you please point to him and identify something he's wearing?
I guess a pale shirt.
Thank you, Your Honor. Let the record reflect that the witness has identified the defendant. I'm showing you what's been marked as People's Exhibit 1. Please take a look at that. And is that a copy of the check that was provided to you on that date?
Yes.
Did he also provide a copy of his ID?
Yes.
And once he provided copies of the check and his ID, what happened next?
So he did, or I handled deposit, and then he wanted to do multiple cash withdrawals.
And did you provide the withdrawals to him?
Yes.
And how were they provided to him?
In envelopes,
Okay,
like different denominations.
okay.
Usually ask for like certain amounts in separate envelopes, so,
And it was cash.
yes.
So the check that was provided to you, what was the amount on that?
It's 30,000.
30,000. Okay, and how many withdrawals were made?
7.
Okay, and what were the amounts of the withdrawals?
So one for $1,024, $960, 1,500, 600, 1,200, and 2,000.
Mr. Chauvin, you have the opportunity to cross-examine this witness.
I have no questions.
All right.
Your Honor, people call Jillian Taylor.
Ms. Taylor, before you get seated, if you'd raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes. Ms. Taylor, where are you employed?
Credit Union 1.
And is that in the city of Berkeley?
I used to be the manager in Berkeley. I'm now at St. Clair Shores, but I was, yes.
I'm going to draw your attention to September 5th. Did you contact, of 2024, did you contact Berkeley PD?
Yes.
Why did you do that?
Our risk management department sent over a packet to send down to them. So when they do that, they just send it to the branch manager. We call and hand that over. It was, from my understanding, it was because bad checks had been passed and was causing us a loss. So they were sending that down.
And the person who had deposited those checks, were they notified to your knowledge?
I believe so, yes.
Okay.
Objection, Your Honor, that's hearsay.
Did you provide a packet from your loss prevention to Berkeley PD?
Yes.
So you gathered everything up and gave it to them?
They gathered everything up. So they sent me the packet complete. I don't actually.
So you just, okay.
Yes, I just handed it over.
Okay, thank you. Your Honor.
All right. Mr. Chauvin.
Your Honor, I have nothing further to say.
Mr. Chauvin, any questions for the detective?
Yes. Sorry. On the date we spoke on the phone, did you have any intent, or did you think I had any intent to fraud the bank?
Objection, Your Honor, calls for speculation.
Same.
All right, I have no more questions.
Lisa. Mr. Chauvin, do you have any witnesses you are calling today?
No.
All right. Will you be testifying? And ask to bind over?
Your Honor, people who provide over in charge of any argument for vote.
Mr. Chauvin, any comments about bind over?
Yes. So to bind over is to go to circuit court, correct?
Correct.
Okay, so I do have one question though. In my attempt to cure debt, I attempted to deposit a bill of exchange, which is lawful, and they rejected it. So why is that not taken into consideration here?
Okay, so your argument is that you tried to cure the debt, and so for those reasons, the case should not be bound over.
Yes.
Okay.
Your Honor, I would just indicate for the record, you did testimony that the bill of exchange that was presented by Mr. Chauvin was indicated to be not accepted as tendered legally to the bank. Furthermore, Your Honor, that's a question of fact for the trier of fact.
All right. The court's heard the testimony from the witnesses today, the arguments of the parties. I find that the testimony provided by the two witnesses from the bank and the detective do meet the probable cause standard required at the preliminary exam to bind over this matter to the circuit court. Mr. Chauvin brought up a potential trial defense. That's an argument that you could make later on down the line. But as of today, that is a question of fact and whether or not that was an actual legal tender that you had provided. And it's not a basis to deny the bind over. So that's something that we'll continue to move on down the line here. I find that the testimony met the burden. So count one is bound over to circuit court for further proceedings and finds to you.
Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599 on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan, the property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order. in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that, because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any rights.
you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go, because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlaw. Ms.
Then
Whitlaw,
you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court.
That I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. To say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and counterclaim to what?
To their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything, and I will speak with plaintiff's attorney as well, and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you. I'm not threatening you. Say one more word and that's 30 days. 30 days.